Good morning, everyone that is here with us in this second session on this International Congress on Constitutional Law, Equality and Non-Discrimination. I'm Daniel Antonio Garcia Huerta, and I'm going to have the pleasure in moderating this session. Before we start, it's important to remind everyone that is following this transmission that we have simultaneous interpreting in Spanish and English. We're going to be transmitting in Spanish through our official page, Facebook, and YouTube channel of the Supreme Court of Justice. And the English transmission is going to be through the Center for Constitutional Studies of the Supreme Court. Likewise, it's important to mention that the tools of chat and questions are active now in the different platforms where we're transmitting in order for you to write your questions, any concerns, or anything that comes up about the topic. The coordinating team for the Congress is going to gather all the questions and is going to send them to the speaker so she can answer those questions. For the Constitutional Studies Center at the Supreme Court, it's extremely important to know the scope, dimensions of the principle of equality. And it goes through this theory, philosophy that sustain everything in law, which was what we analyzed in the prior session. However, it's also very important to understand the different ways in which discrimination can have an impact in the life of people and to know the conditions that bring discrimination to have differentiated impacts in the different people. For this reason, today's session has the purpose of analyzing one of the core questions, core topics in equality and non-discrimination. I'm talking about intersectionality. In order to talk about this topic, it's a pleasure to introduce Professor Shreya Atrey. She is Doctor of Philosophy in Law by University of Oxford, and she has been researching in the analysis of discrimination, feminist theory, poverty, and disability. She has written Intersectional Discrimination, which got the Pitcher Bridge Award in 2020, and she is Associate Professor of International Law and the Human Rights in Continuous Education in the Human Rights Institute at the Oxford University. She also writes in Human Rights Journal for the Center of Constitutional Studies in the Supreme Court. It's an honor to have you here. And we're going to be listening to you. And thank you. You have the floor.
Thank you so much, Daniel. I'll just begin in a moment, but I'd like to first share my screen and check with you if you can see the slides well. Turned on the slideshow. I wonder if you can see the slideshow correctly. I'll try once again. Okay. Fantastic. So thanks so much, Daniel. I really appreciate it. I think I was just saying before we began this session formally that if you get an invitation like this one, you absolutely can't deny it because of the work that is happening in Mexico and at the Mexican Supreme Court. There's deep admiration on this side for everything that you're doing in law there, especially in relation to pushing the boundaries of human rights law in particular. And as you said, really engaging and grappling with what exactly are the human rights violations, what are the kinds of discrimination, what are the deep and affective ways in which people are feeling discriminated against. I think that work that is being done in Mexico, it's really greatly appreciated. So this is an honor. Thank you so much for the invitation, and I'm so glad to be speaking to all of you about intersectional discrimination. So I think I have about an hour but I really hope I don't end up taking as much time, and then there's perhaps more time for questions. I'll try to be as slow as possible for those of you who may be hearing the translated version, because there may be some lag in translation. So I hope that goes well, but if you want me to slow down further, do let me know. So I'll keep an eye out for how everyone is going with the pace of following this. I'm going to be talking to all of you about judging intersectional discrimination today. And I have mainly three things to consider, and I'll be dedicating equal amount of time to all three things. The first is I want to demystify what we call intersectionality. I know it's seen as a very difficult and a hard theory to access, or even to be able to name it and to be able to pronounce it. But I'm just going to try to break it down to explain what intersectionality really means, pulling out from the sources, the vast breadth of sources on intersectionality theory, what exactly I think is the meaning of intersectionality. So we're going to spend some time on that, because that is what is going to help us understand what intersectional discrimination in law is. So I think that understanding in law is deeply, or very closely, it's correlated to what intersectionality theory is. So that's where we want to begin today. The second thing we want to do today is to think about, if we know what the nature of intersectionality or intersectional discrimination is, then why has it been so difficult to adjudicate it? So if you think that something is intersectionality or intersectional discrimination, why has it been very difficult for judges especially to be able to address or redress that form of discrimination? We want to delve on that a little bit to see exactly where the problem in law is for intersectionality. And the third thing is it's aspirational to be able to say a little bit about how can judges effectively adjudicate claims of intersectional discrimination. So obviously one thing we are not going to do today is to leave everyone with the message that intersectionality cannot be adjudicated on. It's too difficult, let's give up. That's not what we're going to leave today with. We're going to think about what are the effective judicial tools to be translating intersectionality theory into the doctrine of equality and discrimination law. I want to say three things about the scope of today's talk before I launch into the first part of the talk. I think the first thing to say is that almost everything that I'm going to be saying comes from comparative discrimination law. And I'm going to be referring to India, Canada, South Africa, US, UK, and European jurisprudence. So it's a vast mix of sources. They're chosen mainly for the reason that some of them really seem to do very well on intersectional discrimination. So South Africa is one jurisdiction where the South African Constitutional Court has really gone leaps and bounds ahead of other constitutional and Supreme Courts. And they really give a very good sense of how can others replicate that progress, or how can others sort of translate that kind of way of thinking about intersectional discrimination into their own jurisprudence. So we're going to be looking at these comparative sources to not just be inspired from them, but to see perhaps also where others are lagging behind, and why jurisdictions do different things differently. The second thing I'm going to say about today's talk is that a lot of what we're going to be talking about is in normative terms. So the perspective that we are going to be taking today is normative in the sense that we are going to be thinking about how should intersectionality be adjudicated, right? So there's an aspirational quality to it, there's a theoretical sense to it, and that is inspired by what has been written on intersectionality theory by intersectionalists or the group of intersectional feminists who work in the area. The third thing to say is that we're not really going to be considering how can parliamentarians or how can national legislatures write intersectionality into their law. We're also not going to be thinking about what are the best ways of strategizing grassroots movements or social movements in an intersectional way. So it's not going to be so much focusing on how can NGOs and practitioners really think about intersectionality to bring alive some of their cases or their political advocacy. We're really going to be concentrating on judicial forum. We're thinking about if somebody wants to bring an intersectional claim, if say somebody wants to come to court and say, I have been discriminated against on grounds of my sex or gender, race, and class, all at the same time. What can judges do about it? Can that claim be admissible? How do we understand claims which are based on more than one ground? So that's the focus of the talk today. So let's look at the first part of the talk where we want to think a bit about what is intersectionality. And in order to be able to think about intersectionality, I think it's best to start with the origin and the background of intersectionality theory. And I've put up 4 sources, what you see on your screen there. And I'm going to walk through these sources to bring out what exactly has happened in the last almost 2 centuries when intersectionality has been engaged with, written about so prominently. It's such a big part of what we call critical theory. What exactly has happened in the trajectory of development of this theory in the last almost 2 centuries? So that's what we're going to be thinking about. So let me begin by saying that intersectionality as a term was coined by Kimberly Crenshaw in her seminal article, which was published in 1989 in the University of Chicago Legal Forum. The article was titled Demarginalizing the Intersection of Race and Sex. And this was the first time she had come up with the term intersectionality. And this was also the first time somebody was writing specifically in the field of equality and discrimination law to explain what intersectionality is. So this article, which is very well known in the field of equality and discrimination law, is often seen as the site where intersectionality was coined, but it's interesting that it's also the site where intersectionality was being coined in relation to equality and discrimination law. So although intersectionality has deep roots in feminist theory, in anthropology, in sociology, it also has very strong roots in equality and discrimination law, given the fact that in fact the term was coined in this context. But what is often also neglected about this point in time, about seeing that intersectionality was not just coined, but originated in 1989, is that it misses what had preceded before 1989. So even Kimberly Crenshaw, when she's coining the term intersectionality in 1989, is drawing on a vast array of resources which come under the umbrella of intersectionality studies today. And she's referring back to almost 150 years of history of people having written and engaged with on intersectionality. The difference simply lies in the fact that the term did not exist. So people had been thinking about intersectionality for very long before the term itself appeared. And simply, a lot of what was being written, especially in the context of the United States, was in the context of Black feminism. So Black women had contemplated about their oppression in the United States, which was at the cusp of both patriarchy and racism, as well as classism or socioeconomic disadvantage. So Black feminists had been interrogating why their position, which was not simply defined by patriarchy alone or the ground of sex or gender, but race and also not race alone, is something more complicated about that. And they had been bringing that their compounded oppression to the fore in terms of the advocacy that they were doing, in terms of the claims they were making. And then finally, when Kimberly Crenshaw came to define intersectionality, to say that those claims were actually failing before the US courts. So this was the context in which the term originated, but also that it has a long history which goes back several decades before the term was actually coined. So the second reference that you see on the screen before you, this is Hancock's excellent exposition and book length treatment of the intellectual history of intersectionality, where she goes back into sources and draws out from the rich Black feminist history how feminists have been thinking about couching their oppression as not simply based on sex or gender, but as going far beyond that, thinking about how does nationality, race, ethnicity, color, language, religion, how do all of them come together to define women's oppression or the disadvantage women face? What's also interesting, I think, at this point, when you try to see exactly what the background of intersectionality is to see that intersectionality, even though it hasn't existed as a term in other cultures, was really a form of thinking and organizing knowledge in many jurisdictions, in many countries, even though the term was never used. And in my own work, I try to show that patterns of intersectional thinking about oppression as co-constituted by several multiple oppressions is something which is very present even in the subcontinent feminist literature. And I particularly look at the Dalit feminist literature in India. And at this point, it might be useful to say that the term Dalit refers to the Marathi. It's a language of the Marathi term broken. It's a reclamation of the space of disadvantage and oppression which Dalits who are assumed to fall outside of the Hindu caste system use for themselves. So like the pride attached to the term Black in the United States, this pride attached to the term Dalit, and those who fall outside of the Hindu caste system, the four-tiered caste system, call themselves Dalit. And Dalit feminism then belongs to those who belong to the intersection of being women as well as being Dalit, as well as being socioeconomically marginalized or poor at the same time. So Dalit feminism is having similar roots to intersectionality in that the claims that have been made by the feminist movement have been very similar to the trajectory of thinking adopted by Black feminists in the United States. And I think similar work is being done now for Chicana and Latina feminism in all of South America, where there's real push to thinking about where have these intersectional patterns of thinking about discrimination, not as through a single lens, but through this multiple, diverse reality of human beings, that we all belong to many groups at once, we have many identities at once, and that disadvantage is co-constituted by these identities. There's real push to thinking in those terms, I think, in the global South. So I think it's useful to refer to much of the Black feminist literature which gives rise to intersectionality as a term, but it's also useful to make connections in the rest of the world to see exactly where are these patterns already existing and whether we can unify what we call as the umbrella under which intersectional scholarship comes within. And I think there's real solidarity and camaraderie in the way feminists have written about oppression, intersectional oppression everywhere. So I think this is something to keep thinking about and keep building on in all of our work. So in my book, I have proposed a way of thinking about intersectionality, which is really derived from those who have preceded before me. It's not a definition that I've come up with in any way for the first time. Everyone who works on intersectionality owes immensely to those who've written before us, and to try to build from what has been existing in the scholarship before something which can help us understand intersectionality better and to take it forward. So in my work, I've tried to propose a definition, which is not the definition, and to cull out from the existing literature 5 things that I think are key to understanding intersectionality. And I suppose one thing to keep in mind when I pass through these 5 criteria in front of you, and I've put them in different colors so that you're able to identify them clearly, is just to have in your mind the reference of Black women, or perhaps Indigenous women or poor women in your mind. It's just a reference point. You may also be able to say, perhaps think of, other kinds of identities, say Muslim gay men who are also intersectionally disadvantaged. You can also think of the category of disabled women. You can particularly think of religious minorities and people who are disabled within those minorities. And you can further think of women who are disabled and belong to religious minorities. So whatever reference works for you, whatever is the easiest case that you, in your context, in your neighborhood, in your workplace, in the spaces that you occupy and inhabit, just think of that. And try to think of, how do you now try to understand that person's disadvantage or that group's disadvantage? It may be a group that you yourself belong to, or it may be a group that you've been thinking about, who you think is particularly deprived on the basis of many characteristics at once. Now that you've thought about that group in your mind, I'm going to keep in mind the group of Black women as well as Dalit women, and I'm going to try to understand, how do I think about their oppression? What is exactly intersectionality bringing to the table in understanding their oppression? So the first thing intersectionality does is it illuminates the dynamic of sameness and difference simultaneously. So you're thinking here about many identities coming together. So say if we're thinking about race and sex, so if you're thinking about, say, being Black and being female at the same time, you're thinking about 2 spheres which come together or collide as a Venn diagram. So people who can think mathematically can think of the 2 spheres coming together as a Venn diagram. And the space in which the 2 spheres collide is defined both by something which is shared by the 2 independent spheres, but also is defined by something unique about that shared space. And the fact that there's something Black women share both with the group of Black men as well as white women is important. Black women don't just start experiencing discrimination, which has nothing to do with the discrimination, say, Black men or white women share. There is a real sharedness of their disadvantage, but also there's distinctive disadvantages that they face at the same time, and it's that quality of facing something which is both similar to the oppression other groups face, but also quite different from them at the same time, which defines intersectionality. Now, I know some of you might be thinking that the Venn diagram imagery is quite a poor one. To imagine that race exists separately from gender and there are 2 sort of watertight categories which then come to collide, it seems a bit untrue, right? Race doesn't exist outside of the category of gender, right? All of us have some kind of racialized, ethnicized way of existing. We all have a sex or gender, and we exist in relation to those categories. They don't exist outside as watertight compartments in which we can say this is how my race operates, this is how my gender operates. So Venn diagrams are not exactly 100% accurate imagery, but they are a good proximate to be thinking about what happens if we think about different spheres of identities coming together. And if you think of it in that way, you open up space to be saying, well, every time we think about discrimination, we shouldn't be thinking in silos. We should be thinking about how do people experience discrimination across groups in a shared and different manner at the same time. The second thing intersectionality shows us is that the shared and unique patterns of discrimination are always patterns of group disadvantage. And this is key in the sense that we're never thinking about intersectionality in individual terms. We're always looking to extrapolate from the individual instance before us to think about, but what about others who may belong to similar categories of disadvantage? What about other Black women who are also disabled? What about their intersection with Black women who are non-disabled, but say who are say extremely rich or extremely poor? So we're always thinking about these patterns of group disadvantage, and we're trying to extrapolate from the individual instances something generalizable that we can say about the group condition. What happens when many people are experiencing multiple forms of discrimination? It's also useful to note that we're thinking about intersectionality in terms of patterns. We're not looking at isolated instances. We're looking at large motives. We're seeing how does discrimination replicate? How does it span not just one or two people, but how does it span entire communities, entire nations? We're looking for these large, big motives, and we're trying to see exactly what happens to discrimination at a real institutional or structural level. The third thing that you have on the screen before you is intersectionality's emphasis on multiple identities understood as a whole. And I think I've touched upon this previously, where I was trying to explain intersectionality not simply as relating to how all of us have these identities which exist separately, right? How do we think about our ethnicity, our nationality, our gender separately, as if they are silos? But we have to think about them as a whole. We have to think about them as having a cohesive experience, because you're just one person. You're facing discrimination as one person. You're not thinking about, today I'm facing discrimination based on my race. Tomorrow it may be discrimination faced because of my gender. But you're really thinking, if race discrimination is what you're facing, then perhaps has gender anything to do with how racialized patterns of treatment come about to be, and vice versa. So you're really trying to infiltrate the thinking of discrimination through different grounds, but also to really consider it together as a whole without trying to bifurcate or separate out people's experiences into different categories. The fourth thing before you is intersectionality's emphasis on context. And this is significant, right? So the reason I'm trying to have you imagine a case of intersectional discrimination which is closest to you is because the context of discrimination is different everywhere. Even within, say, Mexico, there might be far too many communities, spaces, regions, at the small village, town, city level. Different kinds of groups may be experiencing very different ways of thinking about intersectional discrimination, right? So say that the understanding of how does language intersect with gender may be different depending upon different dialects and the way the different dialects reflect class or socioeconomic background, right? It might be different for different regions. Your postcode might matter, and that postcode may have some great association with where you were educated, what kind of education you received. So all of these things, I think, are a matter of context. So it's important to always, when we work on intersectional discrimination, really spell out the context and not try to generalize. And see, what do different words that we use generally, say Black, what meaning does Black have in Mexico? What is Black a category which exists in Africa, or are people just belonging to the many different tribes and nationalities there? There's nothing like Black, but the category Black has great meaning in the United States. So I think it's important for intersectionality not to replicate forms of thinking, but to really translate ways of understanding people's discrimination in the context that they're embedded in, by spelling that context out, by engaging very deeply with that context. The third thing which is brought home by intersectionality theory is that every time you're working on intersectional discrimination or intersectionality theory, you're really trying to upturn the patterns of thinking about discrimination and really transform them. Right? You're trying to change things. You're not trying to just do some new theory, or you're not trying to posit a groundbreaking new idea which cannot be applied. The reason why intersectionality is important and in fact very popular is because that it's committed to bringing change on the ground. It's committed to upturning the patterns of group disadvantage that it reveals. And that is what we mean when we say we're interested in transforming through intersectionality. We don't want people who are multiply disadvantaged or who are intersectionally disadvantaged to be facing such discrimination. We want to disrupt how that discrimination comes about. So I think it's a useful point now then to turn to, if we want to disrupt the incidence of intersectional discrimination in our society, how do we use equality and discrimination law to do that? And the particular question that we want to answer is that, well, if it's been tried before, why has it been so difficult to address intersectionality through law, specifically discrimination law? Some of you may already be aware of this case, but for others, I want to focus on the locus classicus. This was the grand failure of a case before a US court, which is called the de Graffenried and General Motors. And I want to show through this perhaps most famous example of an intersectional discrimination claim, why exactly intersectional claims have failed, but also continue to fail. But then I want to show how exactly have they started to succeed. But you have to wait for that for a bit, because we need to understand exactly why have they stalled or have not been successful so far. So de Graffenried was a case which was brought by Black female employees of General Motors. This is General Motors, the car company. And Black women who were employees at General Motors argued that the last hired, first fired policy at General Motors had discriminated against Black women because Black women were the last to be hired and the first to be fired under the last hired, first fired policy. What they wanted to show was that white women and Black men had both been hired long in the history of General Motors, but it was rather very recently that General Motors had started to hire Black women. So white women had always been in the secretarial jobs at General Motors, while Black men had always populated the ranks of what people would have called the blue-collar workers. Both Black men and white women, the two groups, they had been hired and retained for the longest time. but neither have Black women been part of the secretarial rung, of the administrative rung of General Motors, nor had they been in the workshops, in the factories for General Motors like Black men. They were the last to come in, and hence the first to be fired under the last hired, first fired policy. What they claimed was, because they were facing discrimination, which was a bit similar to what white women and Black men would have faced perhaps, but it was largely something which was distinctive, that neither of the two groups was facing something that they faced. And they described it as discrimination both on the basis of race as well as sex. And they wanted to claim that Black women were being discriminated against specifically as Black women. The court denied their claim, and I have reproduced in front of your screen what the court actually said when it denied the claim, when it said that actually Black women could not claim discrimination based on two grounds. So Black women had to essentially choose whether they wanted to argue on race discrimination or sex discrimination, but not both. And I want to read out to you what the court said. And I quote, "The plaintiffs are clearly entitled to a remedy if they have been discriminated against. However, they should not be allowed to combine statutory remedies to create a new super remedy, which would give them relief beyond what the drafters of the relevant statutes intended. Thus, this lawsuit must be examined to see if it states a cause of action for race discrimination, sex discrimination, or alternatively either, but not a combination of both." The court also said, and I quote, "The legislative history surrounding Title VII." Title VII is the non-discrimination statute in the United States. So the court is saying that the legislative history surrounding Title VII does not indicate that the goal of the statute was to create a new classification of Black women who would have greater standing than, for example, a Black male. The prospect of the creation of new classes of protected minorities, governed only by the mathematical principles of permutation and combination, clearly raises the prospect of opening the hackneyed Pandora's box. So you see, the court has very strong words for saying that it disagrees that Black women have a claim under the non-discrimination statute. And I have underlined some of the things in front of us, which I'm just going to bring up one by one to expose why exactly was the court thinking in this way, but also to expose why exactly was the court wrong in denying Black women's claim, and in fact, how this pattern of thinking about discrimination has been entirely upturned. This is a dated case, but it shows to us what are the origins. Why did Kimberly Crenshaw feel compelled to write about intersectionality in the context of US discrimination law? So I think the first thing that you see before you is that the court is thinking about creating a new classification of Black women. And I think this is interesting, given the fact that in the non-discrimination statutes almost nowhere specify classifications. They're almost all based on grounds of discrimination. So they normally think about discrimination based on race, sex, religion, sexual orientation, disability, etc. But they never quite say that no one should be discriminated who is a Black woman or a white woman or a Black man. Legislations normally don't quite spell out group classifications per se. So for the court to have thought of that the grounds of race and sex could not be combined to think of a classification actually betrays the fact that discrimination law is based on grounds such as race and sex and not really about group-based classifications. So perhaps it would have been useful for the court to think about, can grounds be combined, but not necessarily to think about the specific absence of a protected class of Black women. But what they seem to have been looking for at the time of De Graaf and Reed in 1976 is to read the legislation and think about, oh, has the legislation mentioned Black women? But I think what is also problematic in its reasoning is that they think that by allowing Black women to claim discrimination based on race and sex was to allow them greater standing than, say, for example, is given to Black men under the same legislation. And they seem to indicate, again, this mathematical way of thinking about discrimination by saying that by bringing claims based on more than one ground, you're simply thinking about mathematical permutation and combination. You can just pluck out of thin air many grounds and many groups and just try to say someone has been discriminated against. And to try to think about new classes of protected minorities. All of this is a bit curious because the courts seem to have adopted what is not legislated. The court seems to have adopted a single axis framework to think about discrimination. It is adopting a normative framework of thinking about discrimination on a single ground. Nowhere in the legislation on discrimination, nowhere where you would see constitutions or legislations which specify the guarantee of equality and non-discrimination, saying that discrimination must only be imagined on a single ground at a time and never on any other. This is a normative vision which is being superimposed by judicial thinking. And in 1976, judges framed the idea of discrimination in law in the single axis framework. This was the center of critique for Kimberlé Crenshaw's seminal article. But I want to actually separate out three levels on which intersectional discrimination has been difficult to adjudicate. What I have highlighted to you is the normative limitation that we think that discrimination should only be based on a single ground. But there are two other kinds of limitations I want to bring up and just highlight to you that there may be other silences and there might be other barriers to intersectional discrimination as well. And the first of these is that there may be a legislative or a constitutional barrier. Now, I've just said that it's very unlikely that there are legislative barriers, but it's useful to see if there are any legislative or constitutional barriers in the writing of constitutions, in the way that the non-discrimination guarantees have been written, to see if there's something which prohibits discrimination based on more than one ground to be understood in intersectional terms. But there are, of course, also many, many doctrinal limitations. So there are there is a discrimination doctrine which concerns all features of discrimination law, how we think about indirect discrimination, direct discrimination, comparators, how do we think about evidence, what is the burden of proof, all of these things which lawyers who are hearing this talk may be familiar with. All of these are limitations in the doctrine because none of them seem to quite work for intersectional claims which are based on more than one ground, right? So which is why I think it's useful to not just think about the theory of intersectionality, but also the way it can be translated into the specific features and doctrine of discrimination law. I'm not going to touch on the last part because I think it's quite technical and may not span the breadth of interest which might be more than so people who are attending today might be more than just lawyers who work on equality and discrimination law. So I would not want to bore everyone exactly with the doctrinal limitations, but I do want to focus a little bit more on the normative limitation as well as the legislative and constitutional barriers. But I'm very happy to take any questions on any specific aspects of doctrine which you may want to ask or discuss later on in the Q&A. So I've just told that when intersectionality or intersectional discrimination arose in 1976, and later when Kimberly Crenshaw was writing her seminal piece in 1988, which was published in 1989, there was just one way of thinking about discrimination, and that was single access discrimination. Now you may ask, where are we today? And what you have before you in front of your screen is a list of the many ways in which discrimination based on multiple grounds has been understood by judges. So in my work, what I've tried to do is to systematize almost 30 years of comparative jurisprudence around the world to say that from the first grand failure into graph and read, judges have indeed come a long way in thinking about discrimination in different ways, in different normative frames other than single access discrimination. So what you see here is a list where it proceeds almost as a continuum. So at the top is strictly single access discrimination, which completely denies that discrimination can be based on more than one ground, because the De Graaf and Reed court insisted that Black women had to choose between race discrimination or sex discrimination. But what you have after De Graaf and Reed, after the strictly single access way of thinking about discrimination, are categories which incrementally engage with more sophisticated, more complex ways of thinking about discrimination. And I want to quickly mention a line about each of them. And there are examples in front of you before your screen of each of these kinds of thinking about discrimination, of the specific cases which exemplify this normative thinking. But I'm not going to go into detail at this point. Very happy to take questions if you think a particular category is very important for you to know about. Let's see what lies just ahead of strictly single access discrimination. So one way of thinking about discrimination, which is slightly different from strictly single access, is to admit that discrimination can indeed be based on more than one ground. That say if a person is blind and poor and female, they may be discriminated against on the basis of three grounds of disability, poverty / socioeconomic status, and gender / sex. But you may say that perhaps in this case, it might be easier to say that discrimination can substantially be understood simply as a matter of disability. Right? So you may see a complex case of intersectional discrimination. You may agree that discrimination is indeed complex, but then for the purposes of adjudication, judges may say, actually, this is substantially really got to do with disability. And I think there are cases which show that some grounds seem to be more relevant or impactful in certain cases, which is where judges say, we agree that intersectional discrimination exists, but really substantially we can address this claim on the basis of one ground. Another way of thinking about single access discrimination is to think about capacious single access discrimination. In Sandy Fredman's work, she explains that much of the jurisprudence of the Court of Justice of the European Union really interprets single grounds in a capacious way. So all of the cases before the Luxembourg Court, which have to do with discrimination against older women, say in accessing insurance or in relation to their pensionable age, have really been seen through the lens of either gender or age, but not both of them at the same time. So the CJEU is typical in saying that, look, a gendered understanding must necessarily include an analysis of age and vice versa. So we don't quite need two grounds of discrimination when one ground can be understood capaciously. The final way of thinking about single access discrimination is to think about discrimination contextually. So some judges have said that contextual discrimination really is to take, say, a single ground, but to see it specifically in the context in which discrimination on the basis of that ground transpires. So if you want to say, take the category of women, you may in that particular case think about, oh, where is that woman located? Is the person living in a rural area, or is the person living in an urban area? What is the language that they're using? What's their religion? And how are these different other grounds operating as a matter of context? So judges in this category end up calling discrimination on the basis of multiple grounds simply discrimination based on a single ground, but having a lot of grounds associated as a matter of context. Outside of these four ways of thinking about single access discrimination are other categories. Multiple discrimination is one of them, where courts really say that we allow you to argue your claim based on two grounds. So you can argue your claim based on disability and gender, for example, but you must necessarily show that different kind of evidence goes towards both of them. So we can admit your claim on two grounds, but you must show how each of them are established separately. That's multiple discrimination. Combination discrimination and compound discrimination basically are categories where courts either hype the unique elements of discrimination when two or more grounds are combined, or they hype what is shared by intersectional discrimination, what is shared by intersectional discrimination and discrimination based on single ground, right? So instead of looking at both shared and unique patterns of discrimination at the same time, courts, when they end up seeing discrimination, which is intersectional discrimination, as completely a category different from every other category of discrimination, they think of discrimination as combined, as something which is completely unique in itself and cannot be compared to any other form of discrimination. In compound discrimination, you just end up saying that what Black women are facing is indeed very similar to, say, white women and Black men. In both of those cases, there's real possibility of the case succeeding, but it doesn't quite map onto the first feature of intersectional discrimination that we talked about, that the court is most interested in seeing intersectional discrimination as being both about what is similar, but also something which might be different about discrimination faced on multiple grounds in comparison to single access grounds. Embedded discrimination is another category where a court may say, we see that discrimination is transpiring on more than one ground. Say in the case of Quebec and Canada, the Canadian Supreme Court thought that discrimination was really happening on the basis of Aboriginal status or Indigenous status, as well as residence. But they combined Aboriginality and residence into one ground, which got sort of amalgamated, and the court was saying that discrimination now is happening on the basis of this new combined ground. This is what we call embedded discrimination. And really what the courts do in this case is to make claims of multiple discrimination into single access claims, to say that actually a new ground has to exist for intersectional discrimination to be realized or to be redressed. So all of these categories of discrimination that you see in front of you are ways courts have dealt with multiple ground claims. They no longer seem to be stuck with the idea that normatively discrimination should or must only be based on single access, but they're thinking creatively within the meaning of discrimination and looking further into how they want to think about and redress discrimination. In my work, I've shown that although these different ways of thinking about discrimination have been a step in the right direction, all of them fall short, some by a long shot, some a little less, but all of them do fall short of realizing the 5 features of intersectional discrimination, which are critical to thinking about intersectionality. And really, it's only when we think about how judges can harness all of those 5 features when we really come to see how intersectional discrimination can be redressed effectively. I have before you one case which I want to draw your attention to specifically. This was a case which was adjudicated by the South African Constitutional Court last year in November. This is the case of Mishlango and Minister of Labour, which is an absolutely seminal case. It's a landmark case which shows us how intersectionality can be addressed by judges effectively, but also thoroughly and comprehensively. But it's also an exemplar for the rest of the courts or for people who are working on intersectional discrimination with their clients, or people who are thinking of bringing intersectional claims, to really read this case quite closely to see exactly why it was possible for the South African Constitutional Court to do a good job with intersectional discrimination. To say very briefly, Mishlango was a case where the South African Constitutional Court found that an exclusion which was placed on domestic workers from being able to claim workplace compensation was particularly discriminatory against Black female domestic workers. So domestic workers in South Africa were statutorily excluded from claiming workplace compensation. So if you happen to be injured, or if you died on site while working for an employer as a domestic workers, you or your family would not be able to claim compensation because domestic workers were excluded. Now, South African Constitutional Court saw that this was a case of indirect discrimination. So it was not directly discriminated on any ground, because this was an exclusion based on domestic work. Domestic work is not a ground of discrimination. But it said that since domestic workers are predominantly Black women in South Africa, who are defined by the intersection of classism, poverty, gender, and patriarchy, and race/racism, this is really a case based on the three grounds of race, gender, and class/socioeconomic status. And this is a case which particularly discriminates against Black women who are domestic workers. And the court very cleverly wove in doctrine to be able to say that the way the South African constitutional guarantee is framed under Section 9 of the Constitution really allows for this intersectional way of thinking to be reasoning cases through the lens of the particular group which is before you in the court, and not through an abstract lens. So the particular evidence that was brought by the claimants in Mishlango, as well as the amicus briefs that was filed before the court, really brought to light why it was particularly the demographic of Black women which was being discriminated against, and it was through whom one had to try to understand what was happening in relation to intersectional discrimination. It's an excellent case. I invite people to have a look and to really draw inspiration in terms of thinking very widely and openly about discrimination, and how judges can do a good job at attending to these vast patterns of discrimination which exist in the society. I want to briefly mention legislative and constitutional barriers, because I think the way normally people start to think about intersectional discrimination in law is through what is the letter of the law. And I want to say basically one thing through these three examples which are before you, is that nothing which exists in the text of the legislative or constitutional guarantees really acts as a barrier for intersectional discrimination. So even the most closed off language seems to have been open to accommodating discrimination based on more than one ground. But of course, it helps if your legislation or the particular constitutional language that you're looking at specifically, explicitly engages or recognizes intersectional discrimination. So nothing is a barrier really, but it helps if intersectional discrimination is recognized. So as a first example, I want to highlight the language of the Constitution of India, which under Article 15(1) says that the state shall not discriminate against any citizen on grounds only of religion, race, caste, sex, place of birth, or any of them. Now, the Indian language is interesting because it's perhaps one of the only examples that you can see which seem to indicate a bar for intersectional claims. So you see the word only, where the Constitution is saying the state shall not discriminate against any citizen on grounds only of. It seems to say that they're saying that only single axis discrimination is prohibited, that it's absolutely fine for people to be discriminated against on the basis of their religion, race, caste, and sex combined. So it seems that the Constitution is saying that if you happen to be a woman of a minority religion, and you're born in a specific state where there is a history of discrimination for minority women, then you have no cause of action before the Constitution. This is probably a misreading of the Constitution. And although initially Indian jurisprudence thought that the word only really attached to single axis discrimination, what only has been understood is it's been understood in a causal sense to say that discrimination has to be based particularly on grounds rather than on any grounds. So I think what's important in this example is to see that even the most recalcitrant language in a constitution has been interpreted in a way such as to include multiple grounds of discrimination interpreted intersectionally. And I have before you the case in which this was done. It's been rather recent, but it shows that even the most difficult language can be worked around. The second example is of the Canadian Charter, and that mentions nothing, whether it's about single or multiple discrimination. And I think it leaves open the possibility of bringing in claims of intersectional discrimination. So claims under the Canadian Charter can be of single axis nature or based on multiple grounds. It just depends what we think is the normative vision behind the Constitution and to accommodate more than single axis claims. The South African Constitution is unique in the sense that it particularly includes the language that discrimination can be based on one or more grounds. And I think that specific allowance of having discrimination based on more grounds really is the way to now think about couching new legislations. But of course, even if this particular language does not exist, I think there's enough evidence in comparative practice to show that discrimination can include both single axis and multiple axis claims. I have mentioned that I'm not going to talk about the doctrinal barriers, but I have put up a list before you. So if anyone has questions about how exactly specific features of discrimination law practice need to address intersectional discrimination, I'm happy to address. But I'm going to end by saying two things. First, there's no magic bullet, there's no silver bullet to simply just get intersectional discrimination right. As I said, it requires some patience and some interest in delving into what is the nature of discrimination in the society, and to really try to work backwards from there and to see how exactly can we address discrimination which exists out there in the society in discrimination law. What we have ended up doing instead is we take the law as the parameter or the gold standard and try to fit discrimination, especially intersectional discriminations, into the pigeonholes of law that we have found. I think we need to upturn that or turn it around and to really change our way of doing discrimination law in terms of working backwards from the real cases of discrimination and seeing how can doctrine relate back to more complex intersectional cases of discrimination. That's all from me. Thank you for listening, everyone.
Thank you, Professor Atrey. I think this presentation gives us a much structure and clear outlook and how we can understand intersectionality, and particularly how can we motivate or move forward in the processes of judiciary adjudication of this type of discrimination, particularly in Mexico, where we face some of the obstacle or barriers that you mentioned, legal, the application, and so on. We thank almost 4,700 that are following this conference throughout the different internet platforms. And we have been able to gather some questions that have come up throughout your presentation. And I broke them in two main blocks that have to do with the topics that you have addressed. The first block of questions has to do with respect to judiciary adjudication. A good part of the people that follow us I belong to the judiciary branch. There's also students and academics. And the second block has to do with the need to consider identity and the context that you mentioned at the beginning of your presentation. If it's okay with you, I'm going to be asking you the questions with respect to adjudication and then about identity and context. The first question is about adjudication. Is it possible that judiciary adjudication of intersectional discrimination can result in structural modifications, or is it always about individual remedy mechanism? Is it possible to transform this oppression and disadvantage conditions throughout the courts? The second question is about adjudication as well. Is it possible to consider intersectional discrimination as a two-blade sword in the framework of the judiciary adjudication, because it comes from good intentions? But yes, but what happens when the implementation and the compliance of this decision fails? Wouldn't we be contributing to really perpetrate the disadvantages that we're trying to disarm? And a third question has to do with the proof. We hear that there's so many complexities in order to prove discrimination in different acts. In some contexts, it's about intentionality of the stakeholders, the causality, indirect discrimination, and also, what do you think are the main problems in proof in intersectionality, and what elements of methods of proof could be used to prove this discrimination, if it's about statistical methods or other type of studies that are marked as social, legal, expert reports, anthropology, and so on. Can we answer these first three questions and then we go to the second block?
Daniel, thank you so much. These are such excellent questions, and I think really build on everything that we've talked about until now. So thank you so much for them. I appreciate it. The first question that you asked about was about, can intersectional discrimination sort of lead to structural modification, or is it really about individual remediation? This is a really important question. I've addressed that in my work, and my own view is that everything that intersectionality is about, it's really about looking at specific individual instances of discrimination and using them as exemplifiers, just examples of what may be happening at a group structural level. And I think using these cases for broader structural justice is really important, even for discrimination law, where there are individual claimants who bring some of the cases, right? So unlike in the Mishlango case in South Africa, where the claim was really that the exclusion of domestic workers were particularly harming the entire group of Black domestic workers, most cases of intersectional discrimination really involve one person coming forward. And in fact, in Mishlango as well, there was this one person who was coming forward and saying that her mother had died cleaning the swimming pool of the employer she had worked for many decades, and the daughters didn't seem to get any compensation for that workplace death. And that was the genesis of thinking more broadly, structurally. And I think the last feature of intersectional discrimination or intersectionality theory, that we should always be using intersectional thinking to transform, to really upturn the broader patterns of discrimination so that it doesn't happen again to the very groups which are located at the margins of the society, at the bottom of the rung of discrimination / inequality. I think that's where we need to be going. So really, you answer your own question, whoever has asked this, about can it lead to structural modification? I would think that it will not lead unless we try that. And I think the only way to really do intersectionality well is to press on extracting from individual cases the broader patterns of discrimination, and then to try to do something about those patterns. Remedies here are key. And I think it's always useful to think about how can you give remedies which don't just go to the individual claimant. So in Mishlango, you're not really thinking about how should we address the claim of that one person, the one daughter who came before the court and said, look, my mother has died and she was an employee and she doesn't seem to be getting workplace compensation. Do something about me. It's really taking that case as a specimen. It's shining a spotlight into what is so grave, and in that case, so grave about the South African society, which has deep roots in raciality, colonialism, in patriarchy. And the court used that case as an example for structural remediation. So I think we'll get there if we do it. And I think if we do it, we'll figure out that it is possible. That's the first question. The second question is about, is intersectionality a double-edged sword, that it has good intentions, but is it possible for it to backfire? When it fails, do we really take away from the edge of the theory, the importance of the theory? I think I reckon with that worry. I think sincere application of intersectionality, no matter how hard we try, can fail. And I think no one can guarantee success when you're working with very hard cases of discrimination, right? No one can say, this is a theory, now start bringing claims of intersectional discrimination, go find out about all the indigenous women in Mexico, and really tonight we are all going to really upturn their situation just because we really have decided that we care about intersectionality. I don't think success is guaranteed even with the best intentions, but I don't think we should worry about failure detracting from intersectionality. I think failures even, in fact, go on to show the importance of intersectionality. So, take in the European context, you will be surprised to note that the Court of Justice of the European Union in 2017, when it was specifically asked for the first time to recognize intersectional discrimination in the case called Paris and Trinity College Dublin, the court absolutely denied. It said that you cannot bring a claim based on age and sexual orientation together. You have to separate out the claims. This is what the court ended up saying in so many words. It's so clear what they said. So, that failure, you can interpret it as, having been a failure for intersectionality. I think it's a failure for discrimination law. And I think it's a success for intersectionality nonetheless, given the discourse that it has generated, how much critique the court has had to face, and I think how much possibility of success it is for the next time. So I think the theory itself doesn't diminish its application may have diminished. The practitioners who work with it may feel rejected. But I think these are the spaces that we have to continue to transcend. We all know discrimination is a hard territory, but I think those who are really concerned about the most hidden, isolated forms of discrimination know that intersectionality is a long road, and we have to continue to work through it and not worry so much about failure, because I mean, the history of fighting discrimination is ridden with failures. I mean, we can't be too bothered about failing. I think it's fine if we do. The third question is about proof of discrimination. I think it's such a vast question. I think what I had before you, the last slide there, was really just the list of doctrinal features that we need to work through. Now, I can go through all of them line by line, but I think it'll take us too much time. So I'll draw your attention to the chapter 4 of my book, Intersectional Discrimination, which really takes the reader systematically through how can we work through the entire labyrinth of the doctrine of discrimination law to work with each aspect. I think it requires thinking through very particular things about discrimination law. What are grounds? What is the meaning of grounds, and how do we identify new grounds? What is direct discrimination? What is indirect discrimination? As you asked, what is the relevance of intention? Can we park intentions to one side? Can we only look at effects of discrimination to prove discrimination? How do we identify comparators for establishing discrimination? Do we always need comparators? What is the statistical proof that is needed for intersectional discrimination? Do you necessarily need numbers, or can you do with anecdotal, socioeconomic, social theory, that kind of evidence? What is the burden of proof? So the evidence that is being considered, who is bringing the evidence? You know, a lot of the times discrimination claims, it relies on mining data for evidence. And that evidence may not be easily available to the claimants. It may be with the government. Who brings that evidence? Who must show that discrimination has happened or not happened? And finally, what should the remedies look like? I think each of these need to be reasoned very carefully, and I try to show the ways in which different courts have engaged with each of these specific questions to say that, in fact, there is real possibility in all of discrimination law to reason all of them to work for intersectional discrimination. Right, so I just want to perhaps bring up the one thing that was asked about statistical discrimination. Right, is intersectionality simply about numbers? And do you always need to bring numbers to be able to show that, say, a group like Black women has faced discrimination, which is similar to but also different from, say, the groups of white women and Black men? I think numbers are very powerful. If you can find numbers, if there is statistical data, mathematical, if there's economic data of any kind, it's incredibly helpful to show exactly what the shared patterns of disadvantage are and what the unique patterns of disadvantage are. So, for example, in the case of Black women, you may be able to show that, in fact, Black women have lower levels of employment as much as white women have lower levels of employment in a particular sector. It may be true that, in fact, Black men are ahead, and in fact, women's position by and large is the same. But in that same model of statistics, you may be able to show, and yet there might be difference between how white women are treated and how Black women are treated. So statistics might be really helpful in being able to appreciate what's similar and what's different, right? They make plain. There's something very attractive, very easy about just looking at numbers in front of you. But I don't think numbers are either easy to have access to or that they tell the whole story. You would still need intersectionality theory to be able to say exactly what should be your perspective when you look at numbers. What are you looking for? And I think looking for shared patterns, seeing what may be similar to Black women, because Black women are also facing sexism, which is what all women face. That sexism doesn't become some other kind of ism. I think it's important to stress the solidarity of groups who do face discrimination. They don't just shoot themselves off to a different planet and start experiencing discrimination, which has nothing to do with how people on this planet experience discrimination. It is a shared thing. But also it's something different. And I think that perspective is something you would still need for statistics. If you can have access, I think it's really hard to have access to good statistics. Governments are not collecting this data. They in fact refuse to ask more questions. They refuse to stratify and really demarcate a lot of the data that they're connecting on intersectional grounds. So if you read any of the concluding observations these days from the UN treaty bodies, even I think it'll be a useful exercise for people to see exactly how many times has Mexico been reminded to disaggregate data by the UN treaty bodies, right? CEDAW committee. Disaggregation is the norm, but it's not happening at the pace that you think. So we have to insist on statistical data being collected, but let's not hope that it becomes the gospel, right? There's a lot of analysis needed in terms of, is statistical data showing correlation, or is there causality? What other factors might be there, right? So I think we have to work with statistics rather than treating it as we'll have, an immediate response, even if we have statistics. But there was something very interesting that you said, Daniel, whoever was asking this question, about what other kind of evidence can we bring? And I think when you see cases like Mishlango succeed in the South African Constitutional Court, you're really seeing how well and how responsive the court was to social anthropological evidence. Right? They were really interested in stories, they were interested in history, they were interested in how the people who are bringing the claim characterize that claim in socioeconomic, political, cultural terms. Right? And this vast breadth of what we call social sciences comes to the court's rescue. And I think discrimination lawyers have said this time and again, and I think we'll keep on saying this, that judges who are adjudicating on discrimination law should really be open to that sociological explanation, because there's no legal reality to discrimination other than the social reality. Right? So contract is a figment of law. Law has created this idea of a binding contract. So there are particular legal rules of when a contract is a legal contract. Right, so it's a figment of our imagination, but discrimination is not a figment of legal imagination. Discrimination is out there. So this is a real collaborative space for judges to feel enhanced by amicus submissions, by their investigative powers to ask, summoning committees to look into certain kinds of discrimination, asking governments to give more evidence, asking the right questions of the claimant so that more comes out. And I think it's whether you are an inquisitorial process or an adversarial process, no matter what you formally classify yourself, I think the reality of discrimination throughout the world is the same. This is about people not having access to socioeconomic, political, cultural goods which are relevant for their progress. Right? They're being treated as members of a group rather than being treated as who they are themselves, right? And you want to take away that disadvantage, right? So you inevitably have to look to the individuals within the group. So if we treat it as a collaborative enterprise and really diversify our evidentiary rules for discrimination law, I think we'll be well served, and I think we'll serve intersectional discrimination very well. Thank you.
Thank you, Professor. Yes, different problems to prove discrimination, as you mentioned well. And this is a little bit about going out of the law and to understand what happens in the different communities. And this point allows us to go to the next block of questions, because it's about identity and social context in the framework of intersectionality. The first question is, how is that the analysis of intersectionality can tell us about the relationships of inequality that can exist among the different oppressed groups? An example, it's not the same being a white woman with disability than being a Black woman with disabilities. So even in the analysis of the oppressed groups, there could be differentiated disadvantages. What is the starting point to consider intersectionality? What is our starting point? Second question. At the beginning of the presentation, you talk about the need to consider identities as a whole. This can be true in some identities that are somehow consolidated, like Black race. But what happens with other identities that are not completely or fully defined, like in the case of some sexual diversity or gender? These identities, even in the social arena, are not really determined or defined. How the analysis of intersectionality, how does it play when there's no defined identities? The third question is how intersectionality concepts are related with structural discrimination or historical, because both make the judges analyze context in the history of certain social groups. Okay, that's what we have.
Okay, Daryl, I'll have you repeat the last one at the end, because I didn't catch that entirely. I think I get what you said, but it'll be useful if you can elaborate on it if you have something, but I'll attempt the first two first. There's such good questions. Frankly, I think every time you hear people think about the social theory side of intersectionality, it's so beautiful. And I think that it's so relatable, because it doesn't require the knowledge of law, but it requires such deep thinking about who are we, how do we relate to one another, how are identities constructed in the world. And I think these questions show such deep reflection from those who asked this. So I really appreciate them. So the first question is about, within intersectional groups, say if you are discriminated against on the basis of gender and disability, there's still going to be those who are privileged and others who are going to be disadvantaged. So the case of white disabled women versus Black disabled women clearly shows that within the group of disabled women who are discriminated against, both on the basis of their disability and gender, there are going to be differences, right? There are going to be some who are more privileged on the basis of, in this case, race, but also perhaps in terms of their class. Some may speak the dominant language. Some may live in a very rich postcode. Some may be of a minority religion. Some may be of a majority religion. And I think this complexity of thinking within the group of intersectional groups, such as disabled women, which is quite a nice tight category of disadvantage, right? So in terms of disadvantage, you're both thinking about gender and disability coming together. But how do you then try to think about privilege within this, right? What's the starting point to try to complicate this? I would say don't complicate this if it's not relevant for the particular case, because privilege on specific grounds, specific kinds of identities. It is a norm as much as there is disadvantage, right? Intersectionality is a specific theory of focusing on disadvantage. It does tell us something about how does privilege and disadvantage interact, but largely I think the theory compels us to focus more and more on those who are at the bottom of the hierarchy of disadvantage. So within the case of disabled women, I think it'll be useful to think about who are discriminated or disadvantaged further. So who are the Black disabled women? Who are the poor disabled women? Who are the Muslim disabled women? Who are Muslim and Black and poor and disabled all at the same time? And I think there's layers of disadvantage is what we should be thinking about when we're thinking about the disadvantaged groups. But how do you want to now bring in the privileged groups? I think the privileged groups remain relevant to show the broad patterns of disadvantage, right? Disability, there is something called ableism, right? That those who are not disabled have a particular privilege of going about their everyday life, right? So a white disabled woman her disability will not stop affecting, because that's what I think is the purpose of having these big generalizable grounds, that you never quite forget that disability has a conceptual coherence, right? So I think those other privileged groups, it's useful to see them also as having these dimensions of disadvantage in this broad sense, but also it is useful to use them as comparators to show how others may be yet more disadvantaged than them. So these groups remain relevant both at a comparative level, but also at a generalizable level. And I think that's the kind of interaction we're talking about when we say, think about same and different at the same time, right? It's not one or the other. It's the simultaneous focus on both is what makes intersectionality special. So I think you have to focus on these groups within groups from both of these perspectives. So you can't discard them, but I think you have to use them cleverly to be able to say, not to somehow not reach the conclusion that now white women who are disabled are not disabled, because there is something called disability in this world, but also to be able to say that disability is also co-constituted by class. It may matter how rich or poor you are when you are disabled. Those kind of revealing comparisons are what we should be making when we work with intersectionality. The second question is, it's a beautiful question. Thank you to whoever who's asked about, there is something about wholeness of certain identities. You may have a sort of a more fixed notion of race, but you really don't have fixed notions of sexual orientation and gender identity, and the umbrella group of LGBTQIA plus folks would say, there's always a fluid sense of all of these identities. There's never a sense of, having just decided today that you're say gay or straight, or that there is something ongoing about this umbrella group of gender identity. But I think two things can be said here. One is that I think there is an assumption that categories like race and ethnicity are fixed. And the best way to think about race and ethnicity as not fixed is to think about, and this is the example that I always use, I think people must be tired of me giving this example, but I'll give it again because it's a useful one. Chimamanda Adichie, the Nigerian author who some of you may have read, in her novel Americana, she said that her heroine Ifemelu flew from Nigeria. She took a plane from Lagos, landed in the United States, and realized she had become Black. There is no category like Black in Nigeria. Nigerians are Nigerians. There are different tribes, there are warring tribes, there are different communities, there are different religions. but they're not Black. And the moment her heroine arrived in the United States, she was Black. So race, the notion of race, it's a figment of someone's imagination, given the fact that it has no scientific or biological reality. But the social construct of it is deeply contextual. And it always depends in relation to whom you're talking about. Even racial minorities may have a very different relationship with, say, indigenous minorities, indigenous groups. Right, so race is not as fixed as we think. And I think the more we try to complicate our view of other grounds, the better it is for gender-related grounds to just exist as they are. Rather than try to make them rigid, let's make all of our understanding of race, ethnicity, color also a bit more complex. I think that's one. The second thing is, I think it may be useful to think about SOGI or gender-related grounds broadly in more affirmative terms, that no matter how fluid identities are, they are always having a right to integrity. Now, the right to integrity is a special right? So you only see this specifically spelled out as such in the Convention of Rights of Persons with Disability. This is Article 17. So the UN Convention on Persons with Disabilities has this right recognized. And the purpose behind that right is to say that disabled identities and lives can never be looked at as deficient, as abnormal, as lacking something. Disability is a feature of life in the sense that, today I'm able to walk properly, tomorrow I may not be. In some months I might be. So disability is it's an evolving and a dynamic concept, and nothing about the fluidity of or how one person is experiencing disability should detract from the wholeness of their being. That there is something quite complete about them. And I think disability studies has really helped us see identities in discrimination law in this fashion. And I think for SOGI identities, it's so significant to take inspiration from that to say, I think we should continue to assert the space to be fluid about how we feel about ourselves, but also the fluidity should never detract from being whole and having the right to integrity. So those two things, I think, are what are key into thinking about identities as a whole. What's the wholeness of identities? Daniel, could I ask, what was the third question?
The question is focused to where there's a distinction between intersectionality and structural discrimination, because it looks like both need for the judges to analyze the context in which certain social groups are located. Is it possible to make a difference between intersectionality with this structural distinction, or if both concepts are related? And maybe adding to this question or going deeper, what are the specific advantages about talking about a topic from intersectionality and not only from multiple discrimination that you were discussing in some of the decisions that you mentioned?
Thank you, Daniel. Yeah, I think I get the question now. Thank you to whoever has asked this question. I think they absolutely hit the nail on its head. There is no difference between the kind of discrimination that intersectionality is trying to bring out and structural discrimination. So the nature of intersectional discrimination is always structural. Right? How do we, so there are different taxonomies of discrimination, right? One taxonomy is single axis, multiple axis. Another is direct, indirect. Another is individual, systemic, institutional, structural. And I think all of these taxonomies sort of crisscross. But whoever has asked this question has very nicely and very correctly identified that the nature of intersectional discrimination, it's never individual discrimination, right? Everything that you trying to do and to bring out to life in courts is really that intersectional discrimination is structural, that there are these patterns. You know, how does patriarchy and racism come together? How does class intersect from there? I think these patterns, these vivid patterns, are all structural. If it was ever individual, you know, you'd be able to say, you know, today I have been discriminated against because I'm wearing a brown shirt and my glasses, and because I have straightened my hair. So the reason I've been discriminated against is the color of my shirt, the fact that I'm wearing some glasses and that my hair looks a certain way. That this is individual discrimination, that this has nothing to do with the grounds which serve as these structural reminders that there are these isms. You know, there's the racism, there's classism, ableism, homophobia, patriarchy, right? All of these are the structures the discrimination law is really concerned about. And I think the problem arises when we reduce discrimination law to the specific individual cases, as if individual justice is everything in that case. It is. For those lawyers who are fighting these cases, I think it's important to really focus on the individual cases. But I think these individual cases have no meaning if they weren't part of this structure. The individual case that I talked about the shirt that I'm wearing, it has no structure. People are not normally discriminated against based on the color of their shirt. If they were, there would have been a structure behind why I was treated the way I was, right? So I think it really cannot be emphasized enough that we should use individual cases of intersectional discrimination to speak to and to understand the structure that exists out there. I think they are equivalent. They really are. That's all I have to say about that. Thank you.
Thank you, Professor, for your knowledge, for your comments, for the answers, for your willingness to be here, even though we have about 7 hour difference between England and Mexico, for the Center for Constitutional Studies and for the Supreme Court. It has been an honor to have you, and we hope that in the future we can have your participation in another one of our events. On behalf of the General Director of the Center for Constitutional Studies, Dr. Ana Ibarra, we thank you. We thank the attendance of everybody that followed us through the digital platforms, the Supreme Court, for all the questions and all the comments. Unfortunately, because of time constraints, we cannot answer all the questions, but we try to pick the most relevant and the ones that were summarizing, most things. Before we say goodbye, we want to invite everyone to follow the next conference on constitutional law that is going to take place next Thursday, October 14, from 10 to 11:50, a little bit later than usually, and the topic is going to be affirmative actions. Thank you. Without anything further, thank you for your attention. And Dr. Atrey, thank you for your participation. Have a great day. Goodbye.
Thanks, Al. Thank you, Daniel. Really appreciate everyone's time.